Mic test, 1, 2. Triple docket. Ready to roll. I'm ready, thank you.
Good morning, everyone. This meeting is called to order. Mr. Trowman, has anyone signed up for public comment?
No, sir.
Thank you very much. Good morning, Ms. Miller.
Good morning, sir.
All right, no cases to reconsider under agenda item 3.
Correct.
We have, let's look at tax liability cases under agenda item 4. We have one tax case on docket 51, no cases on docket 52 or on docket 1.
That is correct. The case on docket 51 is case number TD-22-032-0922. Commissioner
I
Demerson,
agree with staff recommendation.
Commissioner Trevino,
I agree with staff recommendation.
and Mr. Chairman.
Agree with staff recommendation.
Thank you very much.
No fair housing cases under agenda item 5.
Correct.
Under wage, on wage claim cases under agenda item 6, we have, let's see, no wage claim cases on 51, 52, or 1. No, nothing pulled for additional discussion.
Correct. None pulled, but you should have received wage claim short form dissent lists for dockets 51, 52, and 1.
I move we accept staff recommendations on the remaining wage claim cases on dockets 51, 52, and 1.
Second chairman's motion, except for the cases on which I'm dissenting, is reflected in the wage claim short form dissent list for docket 51, 52, and 1.
And I concur with chairman's motion, except for those cases in which I am dissenting as reflected on wage claim short form dissent list for docket 51, 52, and 1.
Motion passes with the exceptions noted.
Thank you.
Let's move to agenda item 7, consideration of unemployment insurance cases on docket 51. Please proceed when you're ready.
Case number 2837112, Chairman Daniel.
Because the commission communicated to the public on multiple occasions that no employer would be charged based on claims caused by the pandemic, the employer could have reasonably relied on that information and been misled into failing to respond timely. The response should be deemed timely and the case resubmitted. Reverse the AT, timely employer appeal, resubmit.
When the commission does not yet have sufficient information to make a decision on the employer's appeal from a chargeback determination. Although the appeal was filed 1 day late since the mailing date of the determination, and the appeal period fell within the period of time during the summer of 2020 when TWC and the postal system continued to be substantially overwhelmed, there's a possibility that the employer received the determination too late to make a timely appeal. The owner of the business was out of town for the AT hearing and may have relevant testimony concerning whether the company had mail delivery or late receipt problems during the appeal period at issue. Accordingly, we should hold a rehearing for the purposes of allowing the employer to offer additional testimony from first-hand witness who can address the potential mail delivery or late receipt issue before we determine whether the employer filed a timely appeal.
The AT decision is supportable. The chargeback determination was mailed to the employer's correct mailing address, and the employer filed an appeal 1 day late. The employer has alleged no exception to the timeliness rules. The appeal was properly dismissed for lack of jurisdiction. We agree with the rehearing.
We have 2 votes for rehearing. We will rehear the case.
Case number 2844397, Commissioner Trevino.
The AT decision is not supportable. The claimant in this case had to sign a separation agreement and release of claims in order to receive payment from the employer. The claimant was required to release all viable claims against the employer under federal and state law pursuant to the agreement. The payments made to the claimant were consideration in exchange for the claimant's agreement to voluntarily relinquish substantial rights to the employer. Since the payments constituted consideration as part of such an agreement, they cannot constitute disqualifying severance pay. Reverse the AT, severance pay eligible, no overpayment.
We should modify the appeal tribunal decision. The available record shows that the claimant received the equivalent of 30 weeks of severance pay. The severance pay was not conditioned on any of the non-disqualifying factors found in section 207.049B of the Act, so disqualification is appropriate. However, the severance disqualification for 30 weeks should be measured from the date of the lump sum severance payment and not from the date of the job separation. As such, we should modify the AT decision, severance disqualification from July 5th, 2020 through January 30th, 2021, recalculate overpayment.
Modify the AT severance disqualification from July 5th, 2023 to July 11th, 2020. Recalculate the overpayment.
We have a majority vote that there was a severance payment, but don't believe the dates agree. Commissioner Dimerson and the chairman both started the disqualification July 5th, but the ending dates differ.
Ms. Miller. I agree with Chair.
I'm a short form dissent.
Okay, majority vote is severance pay July 5th, 2020 through July 11th, 2020. And I have your short form dissent.
Thank you.
Thank you.
Case number 2923130, Commissioner Trevino.
The AT decision should be set aside. The claimant changed her address of record during the appeal period for the initial determination, which per commission rule constitutes a timely appeal. The AT nevertheless erroneously dismissed the appeal as late. The AT decision is therefore void and should be set aside. Timely CA appeal, set aside the AT decision, timely AT appeal, remand for merits.
The Claimants Commission appeal should be dismissed as late because it was filed beyond the applicable deadline to do so. Since the record indicates that the AT decision in question was sent to the claimant's proper address of record, and since there are no good cause exceptions to the timeliness rules, we should dismiss the Claimants Commission appeal as late and leave the underlying decision in full force and effect.
Void the AT decision, timely AT appeal, remand.
We will remand the case. You want to go with that, sir?
Yeah, that's fine.
Okay, no dissent.
Case number 2935051, Commissioner Demerson.
We should modify the appeal tribunal decision. The employer provided credible testimony that they did not timely receive the AT hearing notice due to issues with the USPS in forwarding of mail. In addition, the employer further clarified that they were having trouble accessing their electronic correspondence, which prohibited them from accessing any correspondence from the commission or making any updates to their mailing address. Although the employer attempted to contact the commission, they were unable to reach a representative due to the high call volumes experienced by the agency. Since the preponderance of the evidence shows that the employer was prevented from appearing at the AT hearing due to circumstances beyond their control, we should hold that the employer established good cause for missing the AT1 hearing and resubmit the case for merits testimony.
The AT2 decision should be affirmed. The employer failed to appeal for the AT1 hearing because it did not update its address of record with the commission to its new mailing address. Establishing the new address was within the employer's control. The petition to reopen this was correctly denied. On the merits, there was conflicting evidence as to whether the claimant's unsatisfactory work performance rose to the level of misconduct connected with the work. The AT had sufficient evidence to conclude that the claimant was discharged for reasons that did not constitute misconduct connected with the work. Affirmed the AT, no good cause for non-appearance at the AT1, no misconduct, chargeback.
Reverse the AT, employer established good cause for AT1, resubmit.
We will resubmit the case.
Case number 2955095, Commissioner Trevino.
The decision is not correct. The hearing was scheduled over a year after the claimant appealed due to the number of claims filed during the pandemic. Due to the delay, the claimant's failure to appeal was understandable. Although the claimant's appeal was late, as the determination contained an ongoing ineligibility, the commission should resume continuing jurisdiction. The claimant was a self-employed individual who lost most of her business due to the pandemic. The fact that the claimant secured a single job in August does not mean her business was no longer being impacted due to the pandemic. The claimant is eligible for PUA benefits. Reverse the AT, good cause, claimant appeal not timely, PUA not eligible from July 26, 2020 through October 24th, 2020.
And for clarification, do you have record of the date jurisdiction applies?
Yes, ma'am.
What is it, please? You applied continuing jurisdiction. There needs to be an effective date for that.
Or, okay, let me,
Yes, sir.
okay, just to clarify, I wanted to make sure we're assuming jurisdiction from October 24th, 2020.
Thank you, sir.
Yes, ma'am.
Commissioner Demerson?
The AT decision is not supportable. The PUA program was for individuals who were unemployed due to the pandemic. Except for 1 week during late July 2020, the claimant was unemployed due to the pandemic. During that 1 week, she had a short-term job for a client. Her eligibility for PUA would be interrupted for that week, but it would not be canceled simply because she had one paying assignment. After the assignment, she returned to being out of work due to the pandemic. The initial determination was not in accordance with DOL guidelines for the PUA program, and there is no finality to a void decision. Accordingly, we should reverse the AT decision. The claimant filed a timely appeal. The initial determination was void. The claimant was ineligible for PUA for the benefit week ending August 1st, 2020, but resumed being eligible for PUA beginning August 2nd, 2020.
I'm sorry, did you state a vote for the good cause issue?
The timely appeal, the initial determination was void.
There was one good cause issue that preceded the timeliness issue.
1 second. Good cause for the claimant.
Thank you. And Mr. Chairman,
Claimant established good cause for AT1, untimely claimant appeal, PUA not eligible beginning July 26, 2020.
all right, we have majority vote that there's good cause. We have majority vote that there was a late appeal. We have majority vote on the beginning date of the ineligibility. We do not have majority vote on the closure. Mr. Chairman, you left it open, and Commissioner Trevino, you closed it October 24th, 2020. So we'll need a majority vote of some sort on the closure.
Ms. Miller, I'll agree with Commissioner Demerson on that.
All right. So 1 week of ineligibility.
Correct.
And Mr. Chairman?
Short form dissent.
Yes, sir. Thank you.
Case number 3031183, Commissioner Trevino.
Although the claimant's appeal to the commission was late, the appeal tribunal decision was based on requirements not found in the law and is void on its face. The decision holds that the claimant failed to comply with extended benefit work search requirements because he did not make his searches on different days of the week and performed his searches online. These requirements are not contained in the Texas Unemployment Compensation Act. The decision improperly held the claimant to a standard not found in law and is void on its face. The available evidence shows that the claimant submitted his work search log to TWC in a timely fashion with the requisite number of work searches performed. As such, the original determination should be reversed. Deem appeal timely, void the AT decision. The claimant is eligible for extended benefits beginning August 1st, 2021. No overpayment.
Although the AT decision is contrary to several recent decisions by the commissioners concerning the validity of extended benefit work searches done all online and on the same day, the claimant filed a late appeal from that decision. Commission is thus without jurisdiction to consider the merits of the extended benefit and overpayment issues. Accordingly, we should dismiss the claimant's appeal from the appeal tribunal decision as late, leaving in effect the prior ruling regarding the claimant's ineligibility for extended benefits and the overpayment of $1,071.
Late commission appeal, then the AT decision remains in full force and effect.
Short form dissent.
Yes, sir.
Case number 3081580, Commissioner Trevino.
The decision is not supportable. I do not contest the findings that the employer had good cause for missing the first hearing. Regarding the merits, the evidence clearly establishes the claimant was laid off due to lack of work. On 3 consecutive working days, the claimant was informed that there was no work the next working day. Since she was not receiving work, the claimant asked if she could perform a job of another individual. The employer agreed. The employer further apologized that the job had been canceled and that she would not contact the claimant when they got busier. The claimant told the employer to contact her when she had work. The employer did not contact the claimant again. The text message clearly established the claimant was laid off due to lack of work, and the separation was a result of the employer's failure to contact the claimant for additional work, despite stating that they would do so. Modify the AT, good cause, no misconduct, chargeback, severability of claim, and void adequate response.
The appeal tribunal decision should be modified. First, I agree that the employer had good cause for its non-appearance and that the validity of claim and adequate response issues should be severed. As to the job separation, per employer testimony, the claimant quit by completing her last day of work and not asking for further work. The employer presented testimony that had the claimant asked about further work, additional work would have been provided. In some, the circumstances of the case did not provide the claimant good cause connected with the work for quitting, and we should modify the AT decision. The employer had good cause for its non-appearance, voluntary leaving, no chargeback, sever the validity of claim and adequate response issues.
Modify the AT. Employer established good cause for AT1, no misconduct, chargeback, void adequate response, sever validity claim.
I'm sure.
The majority vote is no misconduct, chargeback.
Okay, a short form dissent.
Thank you.
Case number 3117410, Commissioner Trevino.
The claimant's motion for rehearing should be granted. The claimant in this case told the hearing officer at the AT hearing that he had multiple witnesses to testify, but the hearing officer only called 1 witness. The claimant was discharged after an argument between the claimant and the manager in which the employer contends that the claimant acted improperly. The claimant denied the allegation since the claimant offered relevant testimony from witnesses to dispute the facts alleged by the employer. His motion for rehearing should be granted to allow him the opportunity to offer this testimony. Grant MR, rehear the case.
Claimant's motion should be denied. The claimant's motion does not meet all the criteria to be granted. Accordingly, we should deny the claimant's motion for rehearing.
Grant the motion for rehearing.
Motion for rehearing is granted.
Case number 3118509, Commissioner Trevino.
The AT decision is not supportable. I agree that the employer's appeal to the AT was timely. Regarding the separation, the claimant was not on a temporary assignment. The claimant's assignment lasted for 4 years without interruption and ended due to lack of work. The claimant was unaware of the employer's reporting policy and was not reminded of the policy when his assignment ended. Since the assignment was not temporary, and since the claimant was unaware of the need to report back to the employer for further work, it is not appropriate to analyze the separation under section 207.045H of the Act. The separation occurred when the job ended due to lack of work. modify the AT decision, timely employer appeal, no misconduct, chargeback, void adequate response ruling.
The appeal tribunal decision should be modified. First, I agree that the employer's appeal was timely. As to the job separation, the claimant voluntarily quit after he failed to report back for further assignment per policy. The employer is a temporary staffing agency and have provided the claimant with the appropriate information to satisfy 207.045H of the Act. Because the claimant did not report back for further assignment, he quit voluntarily without work-connected good cause. We should therefore modify the AT decision, timely employer appeal, voluntary leaving, no chargeback, sever adequate response.
Timely employer appeal, no misconduct, chargeback, void adequate response.
Short form dissent.
Yes, sir, Commissioner Dimerson.
Case number 3228159, Commissioner Trevino.
The AT decision should be affirmed. The employer had no fault attendance policy and would count any absence against the claimant, even if they were due to the claimant's personal illness. Most of the claimant's attendance issues were caused by her personal illness. Regarding the claimant's final absence, she provided proper notice to the employer that she would be absent because she was sick. Absence due to illness with due notice does not constitute misconduct. Affirm the AT decision, no misconduct, bill employer's reimbursing account.
We should reverse the appeal tribunal decision. The claimant was discharged for exceeding the allowable attendance points after a final warning. By violating the employer's attendance policy, she mismanaged her position of employment. We should reverse the AT decision, misconduct, reimbursing employer not billed, adequate employer response.
From the 18, no misconduct, bill reimbursing employer.
Short form dissent.
Yes, sir, Commissioner Dimerson.
Case number 3270559, Commissioner Demerson.
The commission should grant a rehearing in this case. The employer in their appeal to the commission stated that they had firsthand witnesses who could testify about the final incident which led to the claimant's separation. Since testimony from the witness is critical to ascertain the nature of the claimant's separation, we should conduct a rehearing to obtain testimony from the employer's additional witnesses.
The decision is correct. The claimant was discharged without warning due to performance issues and because of disagreement regarding his use of rental property. The employer admitted that the claimant had not been warned about his performance, that the claimant provided firsthand testimony that he had received permission to use the rental property. The employer has failed to provide evidence of misconduct. Affirm the AT, no misconduct, chargeback.
Rehear.
We will rehear the case.
Case number 3280725, Commissioner Demerson.
We should grant a rehearing in this case. In its appeal to the commission, the employer stated that it had issues logging in and filing an online appeal. It is unclear if this resulted from TWC technical issues or some other agency issue. Based on this allegation, we should grant a rehearing to develop the record on the timeliness of the employer's appeal to the commission.
The employer's appeal to the commission was 3 days late. While the employer alleged to have issues logging into their EBS account and that their fax machine was broken, the employer could have timely mailed their appeal to the commission. Additionally, there is no good cause exception to the timeliness rule. Dismiss the employer's commission appeal as late. The AT decision is left in full force and effect. Valid claim, no misconduct, chargeback.
Can you read the case number?
3280725.
Late commission appeal, the AT decision remains in full force and effect.
Short form.
Yes, sir.
Case number 3282263, Commissioner Demerson.
We should reverse the appeal tribunal decision. The claimant admitted that she had been transferring provider calls instead of handling them as required. She alleged that she did not know how to properly provide the information to the callers, but acknowledged that she had not asked for help, even though she could have. Because the claimants failed to request assistance from the employer and transferred a high number of calls in a few days in violation of the employer's call avoidance policy, she mismanaged her position of employment. Accordingly, we should reverse the AT decision, misconduct, no chargeback, adequate employer response.
The AT decision should be affirmed. The employer has a burden to prove that the claimant was discharged for misconduct. Here, the employer provided secondhand testimony that the claimant allegedly committed call avoidance by transferring calls. The claimant denied the allegations under oath. The claimant was not properly trained to handle calls requiring fax documents, and once she was properly trained, she did not transfer these calls. The claimant was not intentionally violating the employer policy regarding call avoidance, and her actions were merely a result of a training issue. Additionally, the claimant had no prior warnings related to the reason for her discharge. Affirm the AT decision, no misconduct, chargeback.
Affirm the AT, no misconduct, chargeback.
Short form dissent.
Yes, sir, Commissioner Demerson.
Case number 33-05175, Commissioner Trevino.
The AT decision should be modified. The claimant was employed by the employer to take care of her disabled son. She also lived with her son, whose residence was obtained through a housing voucher that terminated upon the death of her son. When her son died, the claimant lost her job, her child, and her residence on the same day. She was therefore unable to report to the employer for reassignment within the prescribed time period. The claimant's separation was urgent, compelling, and necessary, and therefore not disqualifying under section 207.046 of the Act. The employer's account should be also protected from chargeback. Modify the AT, non-disqualifying, urgent, compelling, and necessary separation, no chargeback.
We should modify the appeal tribunal decision. First, I sympathize with the claimant's situation in the death of her son. As to the job separation, the claimant did not follow the employer's policy and notify them that she was available for further work. In fact, she testified that she had no intention of returning to the job after the death of her son. By not following the employer's policy and subsequently filing an unemployment claim, the claimant initiated the job separation. Because she quit for a personal reason, she had not established good cause connected with the work for quitting. Accordingly, we should modify the AT decision, voluntary leaving, no chargeback, sever the adequate response issue.
Modify the AT, voluntary leaving, no chargeback, sever adequate response.
Short form dissent.
Yes, sir.
Case number 33-20821, Commissioner Demerson.
The appeal tribunal decision should be modified. Whether viewed as a quit or as a discharge, the claimant should be disqualified from benefits. If viewed as a quit, the claimant quit voluntarily without work-connected good cause. If viewed as a discharge, the claimant was separated due to insubordination. The claimant was tasked with training a new employee, and the claimant refused to do so. The employer's task was not unreasonable, and as such, the claimant's refusal to follow the employer's directive was misconduct connected with the work. We should therefore modify the AT decision, misconduct, no chargeback.
The AT decision should be reversed. On May 25th, 2022, the claimant asked a question about resignation. The claimant's supervisor insisted that the claimant resign, and despite the claimant's repeatedly denying that she had resigned, the supervisor decided that the claimant's last day would be 2 weeks from May 25th, 2022. In accordance with appeal number 87-00208-10-010488, the claimant was effectively discharged when given 2 weeks' notice of termination. The claimant was reasonably upset by her termination of employment, and her unwillingness to train a new employee during the 2-week period did not constitute a basis for misconduct because she had already been effectively discharged. The employer was offered no evidence of misconduct when they made the decision to end the claimant's employment, and asking a question about resignation is not misconduct. Reverse the AT decision. No misconduct, chargeback.
Reverse the AT, no misconduct, chargeback.
Short form dissent.
Yes, sir.
Thank you.
Case number 33-25488, Commissioner Trevino.
The AT decision should be reversed. The claimant was being forced by management of the employer to work around the clock for multiple days with minimal sleep. The claimant quit due to intolerable working conditions that also constituted a substantial risk to health and safety of the claimant and coworkers. Therefore, had good cause connected with the work to resign. Reverse the AT, no voluntary leaving, chargeback.
We should affirm the appeal tribunal decision. While the claimant may have had a legitimate complaint, he quit without any notice and without addressing his concerns with the employer prior to quitting. By not providing the employer an opportunity to address and resolve the situation, the claimant quit without good cause connected with the work. We should affirm the AT decision, voluntary leaving, no chargeback.
Affirm the AT, voluntary leaving, no chargeback.
Short form dissent.
Yes, sir.
Case number 3358437, Commissioner Trevino.
The decision is not correct. The claimant is the only party to provide firsthand testimony, and she has denied smoking or using profanity. The parties agree with the claimant that the claimant was told around the clock or told to clock out, and that her supervisor would call her. Her supervisor decided not to call her because 2 weeks prior, she had decided not to work the day shift. The claimant was still working the night shift, and there's no reason for the employer to think she had quit working. The claimant was discharged for reasons other than misconduct. Reverse the AT, no misconduct, chargeback.
We should affirm the appeal tribunal decision. The claimant's testimony is in conflict with the initial statement she made to TWC. When filing her claim, the claimant noted that she quit. This is further supported by the fact-finding statement she provided on the day she filed her claim. Because the weight of the evidence established that the claimant initiated the job separation, and she did so because she wanted to look for another job, the claimant quit without good cause connected with the work. We should affirm the AT decision, voluntary leaving, no chargeback.
Reverse the AT, no misconduct, chargeback.
Short form dissent.
Yes, sir.
Okay.
And that was the last UI case pulled for additional discussion on docket 51. You should have received the UI short form dissent list for docket 51.
Sherry. Yeah.
Oh, yes,
Before we
sir.
go back, I wanted to go back to one of the cases. I think it's
Certainly.
Number 3. The third case, rather, it's appeal number 292-3130.
292-3130 is the third case.
Yeah, what was the vote on that one?
Timely appeal remand.
What was timely and,
Timely appeal to CA and remand to the AT for timeliness hearing.
remand, okay. I wanted to short form dissent. I think I agree with that.
You
Short-
did, sir.
Okay,
I'll put you down as a short form dissent.
yes, thank you. Okay,
Thank you.
thank you.
All right, you should have received the UI short form dissent list for docket 51.
I move we accept staff recommendations on the remaining UI cases on docket 51, except for the case on which I'm dissenting is reflected on the UI short form dissent list for docket 51.
I second the chairman's motion, except for the cases on which I am dissenting is reflected in the UI short form dissent list for docket 51.
I concur with the chairman's motion, except for those cases in which I am dissenting, as reflected on UI short form dissent list for docket 51.
Motion passes with the exceptions noted.
Thank you. Moving on to docket 52.
Case number 2768079, Chairman Daniel.
Under the circumstances, the motion for rehearing should be granted because the employer's appeal timeframe occurred when TWC systems were overwhelmed and because the commission communicated to the public on multiple occasions that no employer would be charged based on claims caused by the pandemic. The employer could reasonably have relied upon that information and have been misled into failing to respond timely. The response should be deemed timely and the case resubmitted. So grant the motion for rehearing timely employer appeal resubmit.
And Commissioner Demerson.
Okay, although the employer's appeal from the chargeback determination was late, it appears that the original chargeback determination may not have been based on the employer's actual protest to the notice of maximum potential chargeback. The digital copy of the facts of the employer's alleged protest in the file is blank except for the name of the company representative who signed the form. Unfortunately, the agency no longer has the original form submitted by the employer, since there's a possibility that the employer actually marked one of the chargeback exceptions on the form, but its mark failed to show up in the facts, or else that the employer felt misled by public statements into thinking that the company did not have to indicate a chargeback exception on the form. We should hold a rehearing to allow the employer to offer testimony on those 2 points and on any explanation it may have for its initial response to the NMPC.
The employer's motion for a hearing should be denied. Under Texas Administrative Code 40, Section 815.17, a motion for rehearing shall not be granted unless each of 3 criteria is met. Here, the employer failed to provide specific explanation of how consideration of a new evidence would change the outcome of the case. The employer has failed to state an exception to the timeliness rules, and there is no good cause exception for the timeliness rules. Deny the motion for rehearing, late employer appeal, chargeback.
We have majority vote that the MR should be granted. There's only one vote for a rehearing on the issues, Commissioner Demerson, that you had listed.
I agree with the chairman. Vote.
Okay, thank you.
Thank you.
Case number 2895033, Commissioner Demerson.
The appeal tribunal decision with regard to the employer's non-appearance at the AT2 should be reversed and the case should be resubmitted. The employer stated that the hearing was scheduled at a time prior to the employer's business hours. Since the scheduling of a hearing prior to the employer's business hours was a circumstance beyond the employer's control, it should be found to have had good cause for missing the AT2. We should therefore find that the employer had good cause for its non-appearance at the AT2 and resubmit.
The AT decision should be affirmed. The employer failed to appear for both AT1 and AT2 hearings. At the AT3 hearing, the employer confirmed receipt of the prior hearing notice and testified the reason for missing both prior hearings was because the employer did not prioritize the hearings and overlooked them. As the employer was not prevented from attending the prior hearings by circumstances beyond its control, the employer did not establish good cause to reopen the hearing. The employer responded late to the notice of application for benefits and did not allege delayed receipt of the notice or provide a reason for the late response. The record before AT1 therefore supports the decision. Affirm the AT, no employer good cause to reopen from either the AT1 or AT2 hearings, late employer response.
Affirm the AT, employer did not establish good cause for AT2 or AT1 late protest.
Short form dissent.
Yes, sir, Commissioner Demerson.
Case number 3049981, Commissioner Demerson.
The appeal tribunal decision should be modified. The facts in this case reflect that the claimant's separation was a result of poor attendance. However, the record establishes that the claimant's attendance issues were the result of illness. As such, the claimant should continue to be qualified for benefits, but the employer's account should be protected from charge under medical separation analysis. We should therefore modify the AT decision, no misconduct, no chargeback, MVI.
The AT decision is supportable. In accordance with section 201.091, the claimant waited more than 3 business days to file his initial claim for benefits. No further work was made available to the claimant during those 3 days. Therefore, his claim was valid. The employer was a temporary help firm and not a staffing company. Therefore, section 207.045I of the Labor Code is not an issue. Job separation was correctly analyzed under section 207.044 of this act, as the claimant was involuntarily separated when he completed his assignment. But no further work was made available. The claimant's firsthand testimony established that he was told by the employer's representative that he did not have to report back the following business day because no further work was available. Affirm the appeal tribunal's decision, no misconduct, chargeback.
Modify the AT, no misconduct, no chargeback, disaster.
I agree with the chairman.
Thank you.
Thank you.
No misconduct, so the claimant will be paid and the employer will be protected. I need to
Agree.
know, you agree?
I agree.
Yes, sir. Unanimous decision.
Case number 3104135, Commissioner Trevino.
The AT decision is not supportable. The claimant was discharged pursuant to a retroactively applied attendance policy. The previous policy provided attendance points rolled off after 6 months, whereas a new policy made attendance points active for a year. The new policy was effective 1/1/21, but the claimant was not notified about the change until July 2021. 3 attendance points would have rolled off under the old policy by the time the claimant was notified of the change. 3 more attendance points were accrued by the complainant between 5/30/21 to 6/2/21, also before he was made aware of the change. Those points would have rolled off under the old policy within days of the claimant's dismissal. Thus, 6 of the 7.5 points the claimant had on record were accrued before the claimant was even aware that they would count against him for the year. The claimant's violation of the attendance policy, of which he was not made aware, did not constitute misconduct connected with work. Reverse the AT, no misconduct, chargeback, void adequate response.
We should modify the appeal tribunal decision. The claimant was aware of the employer's policy on the absences at the workplace. The claimant was repeatedly warned about his absences and was aware that further attendance infractions could result in termination of employment. The claimant was terminated when he exceeded the allowable absence points as outlined in the employer's policy. Since the claimant was repeatedly counseled about his attendance, but thereafter continued to accrue attendance points in violation of the employer's policy, the claimant's conduct was mismanagement of his position of employment and was misconduct connected with the work. Hence, we should modify the AT decision, misconduct, no chargeback, sever adequate employer response.
Reverse the 18, no misconduct, chargeback, void adequate response.
Short form dissent.
Yes, sir.
Case number 3108621, Commissioner Trevino.
The AT decision should be set aside because there is no work separation in this case. The claimant only worked 1 day per week for the employer, and she took 1 day off work. She resumed her normal work schedule on the following scheduled work day. Despite her absence for 1 day of work, the claimant had a continuing work relationship with the employer, and she was not separated from the job merely by taking 1 day off. Set aside the AT, void separation determination, no work separation, no overpayment.
The appeal tribunal decision should be affirmed. I did not contest the validity of claim issue. As to the job separation, the claimant initiated the job separation by filing for benefits after being granted leave by the employer. Since the claimant was the party to initiate the job separation, and because she did so for personal reasons, she quit without work-connected good cause. And we should we should affirm the AT decision. Valid claim, voluntary leaving, overpayment.
Set aside the AT, void the continued claim and overpayment.
So the majority vote is to set aside the AT and void the separation. Did you want to dissent?
Yeah, I'm in dissent.
Thank you.
Thank you.
Case number 3144376, Commissioner Trevino.
The AT decision is not supportable. The claimant provided uncontested, credible, and persuasive evidence of delayed receipt of the AT1 decision. The claimant promptly filed his petition to reopen once he had received the AT1 decision. The commission took 11 months, which is an unreasonable amount of time, to process and schedule the employer's AT appeal for a hearing. In the meantime, the claimant had filed and received benefits for 6 months, found another job, and moved. As the claimant was completely unaware of the employer's appeal, and because he had stopped filing payment requests, it was reasonable for the claimant to believe that he only needed to update his address with the post office, which he did. Since the lack of commission resources was a reason the commission failed to timely process and schedule the AT1 appeal hearing, the claimant petition to reopen was deemed timely. Reverse the AT2 decision, timely petition to reopen and resubmit for merits.
The appeal tribunal decision should be affirmed. The claimant's Rule 16 petition to reopen was filed beyond the applicable deadline to do so. The record also reflects that the claimant received the AT decision late because he failed to update his address with TWC. There are no good cause exceptions to the timeliness rules, and the claimant's petition should be dismissed. You should therefore affirm the AT decision, untimely Rule 16 petition to reopen, leave the underlying decision in full force and effect.
Reverse the AT, timely petition to reopen, resubmit.
We will resubmit the case.
Case number 3178805, Commissioner Trevino.
The AT decision should be modified. The claimant filed an appeal to AT on 3/22/21, explaining why she missed the reemployment services class and requesting to reschedule the date. The appeals then waited over a year later to reschedule the date. Appeals then waited for over a year later to schedule her hearing. The claimant attempted in good faith to report and provide requested information about why she missed the profiling class, and she should not be prevented from receiving additional benefits on her claim merely because a hearing was delayed so long after she appealed. The commission can assume jurisdiction over the case or over the late appeal as early as 3/8/21. We should close the reporting eligibility effective 3/13/21. Modify the AT, late AT appeal, profiling ineligible from 2/7/21 to 2/13/21. Continuing jurisdiction over open period reporting effective 3/8/21 and reporting ineligible from 3/7/21 through 3/13/21, an overpayment.
The appeal tribunal decision should be affirmed. The claimant filed her appeal beyond the applicable deadline to do so. There are no good cause exceptions to the timeliness rules, and the underlying decision is supportable and should remain in full force and effect. Accordingly, we should affirm the AT decision, untimely claimant appeal, leave the underlying decision in full force and effect.
Modify the AT, untimely claimant appeal. Reporting not eligible from March 7th to March 27th, 2021. Profiling not eligible February 7th to February 13th, 2021. Recalculate the overpayment.
Just to confirm the dates, Commissioner Trevino, for the reporting ineligibility, you closed that on 3/21.
No, that was 3/13/21.
Okay, let me just confirm both date ranges with you. So for the profiling, please.
The profiling was ineligible from 2/7/21 to 2/13/21.
2/13/21. Yes, sir. And the reporting, please.
Yes, so I'll agree with the chair.
Yes, sir.
Short form consent.
Yes, sir. Thank you, gentlemen.
Case number 3194014, Commissioner Demerson.
The appeal tribunal decision should be reversed. The job separation in this case took place prior to October 11th, 2021. The employer initiated a vaccination policy which provided for exemptions. The claimant did not submit an exemption and instead choose to resign. The employer in its response also stated that work was still available had the claimant chose to stay with the employer. Accordingly, the claimant quit for reasons that did not constitute good cause connected with the work. We should therefore reverse the AT decision, voluntarily leaving, reimbursing employer not bill, adequate employer response.
The decision to qualify the claimants is supportable. The job separation should have been analyzed as an involuntary discharge since the claimant gave more than 3 weeks' notice. and the employer provided no choice. It was either submit to the vaccine or be discharged. Regardless of the claimant asserted a compelling personal reason for refusing to submit to the vaccine, and the governor's executive order GA 40 simply underscores she was justified in leaving. Further, it should be noted that the employer failed to establish a compelling business and public health interest, as the claimant simply worked as a scheduler, and there was no evidence that she had any contact with patients or clients. Affirm the AT decision, no voluntary leaving, and bill the reimbursing employer account.
Reverse the AT. Voluntary leaving, reimbursing employer, not billed, adequate employer response.
Yeah, short form dissent.
Yes, sir.
Case number 3197237, Commissioner Demerson.
We should grant the employer's motion for rehearing. The employer is offering no new evidence, specifically the testimony of the owner who was involved in the interactions with the claimant, which led to the job separation. This witness was not able to participate because he was called to another job site with unreliable cell phone service. Testimony from this firsthand witness would establish the events that led to the claimant's job separation and change the outcome of the case. Accordingly, because the employer has met the 3 required criteria, we should grant the employer's motion for rehearing.
The employer has filed a motion for rehearing, arguing that the employer's owner was a firsthand witness and who was unable to participate at the AT hearing because the store location to which they traveled had spotty cell phone coverage. However, there is no indication in the record that the witness even attempted to call in for the hearing. Also, no information was provided by the employer's cell phone provider to establish that they would not have coverage in that area in question. Lastly, the employer was represented by an attorney, and there was no indication that the employer's attorney requested a postponement of the hearing due to the unavailability of the employer's firsthand witness. The rule has failed to meet the MR criteria set forth in Rule 817.17 F2. Deny the motion for rehearing.
Grant the motion for rehearing.
The motion for rehearing is granted.
Case number 3210164, Commissioner Trevino.
This case should be reheard to further develop the record regarding what occurred at the end of the employment relationship. Currently, the available evidence contains conflicting information from the employer about when and how the employment relationship ended. The employer indicated that the claimant quit by failing to return to the office on February 22nd of 2022, but also indicated that the claimant was a no-call, no-show on March 7th of 2022. The claimant indicated that she was fired because the employer asked her to return her work equipment. Additional evidence is needed to determine the party who initiated the work separation and when the work separation occurred.
We should reverse the appeal tribunal decision. The claimant quit when she did not report to work per the employer's instructions. Although the claimant alleged complaints about her work environment, the claimant failed to support her assertions through any specific examples and relied on generalized assertions of discomfort. Since the claimant quit due to generalized displeasure with the workplace, and because she failed to provide the employer with an avenue to mitigate her concerns prior to her resignation, the claimant's separation was a voluntary quit without work-connected good cause. Hence, we should reverse the AT decision, voluntary leaving, no charge back, adequate employer response.
Reverse the AT, voluntary leaving, no charge back, adequate employer response.
Short form dissent.
Thank you.
Case number 3214726, Commissioner Trevino.
The decision is not correct. The claimant experienced technological issues when she tried to open the instructions for filing her claim certifications. As a result, she was unable to file her certifications for several weeks until she was able to get assistance from a TWC representative. The claimant has shown adequate cause to backdate her claim certification due to the technological issues she experienced. Reverse the AT, filing ineligible.
We should affirm the appeal tribunal decision. Upon filing her initial claim for benefits, the claimant was provided information on filing and the procedures for requesting benefit payments. The claimant failed to timely file her claim certifications because she did not properly read the filing instructions. Since the claimant failed to file her claim certifications in accordance with commission rules, we should affirm the AT decision, filing not eligible from December 12th, 2021 through April 16th, 2022.
I agree with Commissioner Demers.
Short form dissent.
Yes, sir.
Case number 3227393, Commissioner Trevino.
The AT decision should be affirmed. The claimant was discharged from his last job with the named employer for attendance issues related to his ill child. Since the subsequent offer to work was from the same employer as the claimant's last job, and the work separation was not due to lack of work pursuant to commission precedents, the claimant did not refuse an offer of suitable work. Further, there is insufficient evidence that a bona fide offer to work was made, as no start date was established, and the claimant did not expressly decline an offer. Finally, the offer did not constitute suitable work because a new position would have been substantially different than the claimant's last job. Affirm the AT suitable work eligible.
We should reverse the appeal tribunal decision. The available record shows that the employer offered the claimant a new job position at the completion of his work assignment. Moreover, the evidence shows that the new assignment offered by the employer paid in excess of the claimant's maximum wage demand. As such, we should reverse the AT decision, suitable work disqualification.
Reverse the AT, suitable work disqualification.
Short form dissent.
Thank you, sir.
Case number 3249850, Commissioner Demerson.
The appeal tribunal decision should be reversed. The claimant was fired for using profanity in front of other workers. The claimant stated that he could not recall the statement that the employer attributed to him. However, not recalling something is not the equivalent of a firsthand denial. As such, the employer's secondhand account should be given additional weight. Accordingly, the claimant's action of using profanity in front of the other workers was mismanagement of his position of employment and misconduct connected with the work. We should therefore reverse the AT decision, misconduct, no chargeback, adequate employer response. In the alternative, the commission should grant a rehearing in this case. In its appeal, the commission, the employer offers its firsthand witness for the commission's consideration. As such, we should rehear the case to take testimony from the employer's firsthand witness and to also enter the employer's additional correspondence into the record.
The AT decision is correct. The claimant was discharged because he was accused of using profanity when he told a sales manager that he was going to leave the job when he found another job. The employer has provided no firsthand evidence of the claimant's supposedly profanity. The claimant acknowledged telling his manager that he was going to find another job, but denied using profanity. While it was probably unwise to tell the employer that he was looking for another job, it does not constitute misconduct connected with the work. The employer failed to meet its burden to establish misconduct by a preponderance of the evidence. Affirm the AT, no misconduct, chargeback.
We're here for employer firsthand testimony.
We will rehear the case.
Case number 3270724, Commissioner Trevino.
The decision is not supportable. The employer was providing company vehicles for employees. They decided to no longer provide company vehicles for transportation, but offered to sell the vehicles to their employees. The claimant declined to purchase a vehicle and quit. The claimant had an accident in her personal vehicle, and without the company vehicle, no longer had transportation. Since the employer assumed responsibility for providing transportation and removed that option, the claimant's lack of transportation provided her with good cause to connect with the work to quit. Reverse the AT, no voluntary leaving, chargeback. In the alternative, if my fellow commissioners do not believe that the record regarding the employer's company vehicle program has been adequately developed, I could agree to a rehearing to qualify when the program was in effect and when it ended.
We should affirm the appeal tribunal decision. The claimant was involved in a car wreck which totaled her car. Although the claimant was temporarily authorized to use the employer's fleet vehicle for personal transportation, the record indicates that the claimant failed to accept the employer's offer to buy the fleet vehicle or provide an alternative method of transportation to work. Since the record indicates that the claimant was aware of the employer's requirement to provide personal transportation, the claimant's resignation due to lacking effective transportation constituted a voluntary quit without work-connected good cause. Hence, we should affirm the AT decision, voluntary leaving, no chargeback.
Affirm the AT, voluntary leaving, no chargeback.
Short form dissent.
Yes, sir.
Case number 3275408, Commissioner Demerson.
We should modify the appeal tribunal decision. The employer implemented a progressive disciplinary policy on absences and tardinesses at the workplace. The claimant was on final warning for her absences and was aware that further attendance infractions could result in termination of employment. Concerning the final incident, the claimant was terminated when she did not maintain proper transportation, which resulted in her subsequent absence in violation of the employer's attendance rules. Since the claimant was aware of the employer's policy, but thereafter continued to violate the rule through her absence at the workplace, the claimant's actions constituted misconduct connected with the work. Hence, we should modify the AT decision, misconduct, reimburse an employer not billed, sever the adequate employer response.
The AT decision is not supportable. The claimant was discharged for excessive absenteeism in violation of the employer's policy. However, the employer did not dispute that the claimant's absences were caused by the claimant's medical condition for which she was granted FMLA leave. While the final attendance infraction may not have been caused by her health condition, the majority of her infractions were caused by her condition. The claimant's violation of the attendance policy due to her medical problems did not constitute misconduct connected with the work. Reverse AT, no misconduct, bill reimbursing employee, avoid adequate response.
Modify the AT, misconduct, reimbursing employer not billed, sever adequate response.
Short form dissent.
Thank you, sir.
Case number 3288417, Commissioner Trevino.
The AT decision is not supportable. The employer has characterized this assignment as a temporary assignment, but the claimant worked on his last job for the employer as a sales assistant for 2 years. Section 201.011, 20, and 21 of the Act describe a temporary employee of a temporary help firm as an employee who works for the client to support or supplement the client's workforce during the employee's absences. Temporary skills shortages, seasonal workloads, or special assignments or projects. The claimant's 2-year-long job clearly meets none of these conditions. Since the claimant was not a temporary worker, the reporting requirements in section 207.045H of the Act do not apply. The claimant was laid off when the work ended under non-disqualifying circumstances. Reverse the AT, no misconduct, chargeback.
We should affirm the appeal tribunal decision. The claimant had acknowledged the employer's policy, which required her to immediately contact the employer for further work upon completion of a work assignment. Although the claimant alleged that she attempted to contact the employer's client, the claimant failed to contact the employer until 2 weeks after the work assignment had ended. Since the employer's policy required its employees to immediately contact the employer at the end of the work assignment, the claimant's failure to abide by the employer's time frame for reporting constituted a voluntary quit without work-connected good cause. Therefore, we should affirm the AT decision, voluntary leaving, no chargeback.
Reverse the AT, no misconduct, chargeback.
Short form dissent.
Yes, sir, Commissioner Demerson. And that was the last UI case pulled for additional discussion on docket 52. You should have received the UI short form dissent list for docket 52.
I move we accept staff recommendations on the remaining UI cases on docket 52.
And I second the chairman's motion, except for the cases on which I am dissenting, as reflected in the UI short form dissent list for docket 52.
I concur with Chairman's motion, except for those cases on which I am dissenting, as reflected on UI short form dissent list for docket 52.
Motion passes with the exceptions noted.
All right, we'll proceed on to docket 1.
Case number 2987768, Commissioner Trevino.
Despite his non-appearance at the hearing, the AT decision was favorable to the claimant. The decision was later reversed by the commission. Under commission rule, since the claimant received a favorable decision despite his non-appearance, he is entitled to a rehearing to consider whether he had good cause for his non-appearance. If good cause is established, the rehearing shall address the merits of the case. The claimant did not appear at the AT hearing because he was working at the time and did not receive the hearing notice. The claimant has established good cause for his non-appearance, and the case should be resubmitted for merits. Grant the motion for rehearing. The claimant has good cause for their failure to appear at the AT hearing, and resubmit for merits.
I agree that we should have granted the claimant's motion for rehearing to take testimony on whether the claimant had good cause for missing the AT hearing. Regarding the good cause issue, the claimant alleged that he may have been working during the time of the hearing, but he did not know for sure. And even if the hearing had been scheduled during work, the claimant was not working a new job. So he could have asked for time off to attend the hearing. The claimant also speculated that he may have not received the hearing notice due to having moved from one address to another during the applicable time frame. However, TWC records indicate that the claimant has not updated his address with the agency since he filed his claim. Therefore, since the claimant had not established a good cause for his non-appearance, we should not disturb our prior decision. Accordingly, we should grant the claimant's motion for rehearing, find that the claimant did not have good cause for missing the AT hearing, and leave the underlying commission decision in full force and effect.
Grant the motion for rehearing. Claimant establish good cause for AT1 resubmit.
We will resubmit the case.
Case number 2990257, Commissioner Demerson.
We should modify the appeal tribunal decision concerning the notice of maximum potential chargeback. Since the notice was sent during the time frame that TWC was experiencing known technical difficulties, the employer's response should be deemed timely. Concerning the job separation, the record shows that the claimant initiated the job separation when she first quit her assignment and thereafter failed to report for work in violation of the employer's policy. Since the employer testified that the claimant was aware of the employer's rule on reporting, but thereafter failed to report for further assignments, the claimant's conduct was a voluntary separation without work-connected good cause. Hence, we should modify the AT decision. The employer filed a timely response to the notice of maximum potential chargeback, no chargeback.
The AT decision should be modified. I agree that the employer's protest should be deemed timely. However, the employer's account should remain charged. The employer failed to appear at the rehearing to provide more evidence about their reporting policy. The employer provided no evidence that their reporting policy informed the claimant that her failure to report her availability could cause her unemployment to be denied. As such, she did not consider to have voluntarily quit under section 207.045H of the Act. The claimant was laid off when her assignment ended and discharged for reasons other than misconduct connected with the work. Modify the AT decision, deem employer's protest to the notice of maximum potential chargeback timely, and chargeback.
Modify the AT timely response to the NMPC chargeback.
That was timely response in chargeback, sir.
Timely response to the NMPC chargeback.
Thank you.
Short form dissent.
Yes, sir.
Case number 3016575, Commissioner Demerson.
The AT decision is not supportable. Concerning timeliness of the employer's response to the NMPC, the employer gave credible and consistent testimony that the company responded in May 2020 within the timeframes allowed for a timely response. The traditional so-called technical difficulty period recognized by the agency is associated with the pandemic, which is stated as mid-March through April 2020, is unrealistically short. We know that TWC's phone, fax, mail, and online systems were comprehensively overwhelmed from the beginning of this pandemic through at least September or October of 2020, if not later, based on the calls, emails, and letters received by my office alone. Thus, the employer's consistent testimony is credible proof that the company responded in a timely manner. Accordingly, we should reverse the AT decision and find that the employer filed a timely response to the chargeback notice and then resubmit the case on the merits of the chargeback issue.
The employer has provided testimony that they experienced technological issues when attempting to file their protest. Although the employer has not provided evidence of a timely protest, since they have alleged TWC systems issues were responsible for the failed receipt, the employer's protest should be deemed timely and resubmitted to address the issue of chargeback. Reverse timely notice of maximum potential chargeback and resubmit.
Reverse the AT, timely response to the NMPC resubmit.
Thank you. We have unanimous decision.
Case number 3029972, Commissioner Trevino.
The AT decision should be modified. The claimant was off work for about 2 to 3 weeks in December of 2020 and January 2021 due to severe illness from COVID. The claimant provided medical documentation of his COVID illness, but because of limited appointments and healthcare resources, he could not get a medical documentation that the employer required to release him to return to work. December 2020 was one of the worst months of the COVID pandemic, and access to healthcare was extremely limited at the time. Although the employer argued that the claimant quit when he failed to provide additional medical documentation, he was actually fired by the employer when they refused to allow him to return to work after his recovery. The claimant was discharged for reasons that did not constitute misconduct connected with the work. Since the claimant's separation was caused by his medically verified illness, the employer's account could be protected from chargeback as well. Modify the AT, no misconduct, no chargeback due to MVI, void the adequate response rule.
The appeal tribunal decision should be modified. The claimant stated that he had received the employer's December 30, 2020 text, which notified the claimant he needed to submit medical documentation related to his absences. Nonetheless, the claimant went on to state that he did not supply the requested documentation. Given the circumstances, the claimant failed to take the appropriate steps to adequately protect his job and was separated due to work-connected misconduct. We should therefore modify the AT decision, misconduct, no chargeback, sever adequate response.
Modify the AT, misconduct, no chargeback, sever adequate response.
Yeah, short form dissent.
Yes, sir.
Case number 3035867, Commissioner Demerson.
The AT decision is not supportable based on the evidence currently available. The chargeback notice was mailed out during May 2020 when the pandemic was still in full force and effect and was causing TWC and postal systems to be overwhelmed. Although the testimony from the employer's witness did not offer firsthand testimony concerning the employer's earlier attempts to change its address of record with TWC, the president of the company mentioned that the company's CPA had attempted several times to file an address change with the agency. If the CPA had attempted by any reasonable means to change the employer's address of record, and at least one of those attempts happened before the mailing of the NMPC, in this case, the employer's response to the notice sent to its old address should be considered a timely response to the NMPC. It does not appear that the hearing officer gave the employer an opportunity to get its CPA on the line to offer firsthand testimony regarding the address change attempts. Accordingly, we should hold a rehearing for additional evidence from the employer concerning the attempts by the employer's CPA to change the employer's address of record, specifically covering the questions of whether the change requests were actually submitted to TWC, when they were submitted, and whether the employer's CPA had a reasonable basis for believing that the address change request had gone through.
The AT decision should be affirmed. The employer moved to a neighboring suite within the same building, but failed to update its address with the commission. As the employer was repeatedly giving commission correspondence addressed to their old suite by the new occupant or by the mail carrier, the employer knew or should have known that the commission did not have its updated address. Pursuant to Texas Workforce Commission rules, if a party provides the agency with its own incorrect mailing address, an agency mailing to the address is considered a proper mailing. The notice of maximum potential chargeback was mailed to the employer's correct address of record, and the employer did not protest the notice by the deadline date or overcome the presumption of a receipt. Affirm the AT late employer response to the notice of maximum potential chargeback.
Reverse the AT. Timely response to the NMPC resubmit.
Your vote was to rehear.
Yeah, I'm agree with the chairman though.
Thank you. Timely response and resubmit. And we'll resubmit it.
Okay, thank
Yeah.
you.
Case number 3094454, Commissioner Demerson.
The appeal tribunal decision should be modified. I agree that the employer submitted a timely response to the notice of maximum potential chargeback. As to the job separation, the claimant was fired for job performance after prior write-ups. Claimant's task, as described by the employer, did not appear extremely complex or difficult in nature, such as making sure food was defrosted and making sure that there was enough product for an event. In some sense, it's reasonable to conclude that the tasks were not complicated in nature. It is also reasonable to conclude that the claimant was not working to the best of his ability and failing to complete them. Should therefore modify the AT decision. Timely employer response to the notice of maximum potential chargeback, no chargeback.
The AT decision should be affirmed. I agree that the employer's protest should be deemed timely. Regarding the chargeback issue, the employer's account should remain charged. There is no evidence that the claimant was not performing to the best of his ability. His inability to meet the employer's standard or his inability to perform the work to the employer's satisfaction does not constitute misconduct. Affirm the AT decision, deem employer's protest to the notice of maximum potential chargeback timely, chargeback.
Modify the AT. Timely response to the NMPC, no chargeback.
Short form dissent.
Thank you, sir.
Case number 3130440, Commissioner Trevino.
The AT decision is not supportable. The claimant missed the hearing because she was traveling out of state to a family member's funeral and was busy handling the deceased estate. Since the claimant was unable to participate in the hearing due to circumstances beyond her control after the death of a family member, the claimant has established good cause for missing the hearing. At the AT decision should be modified. Claimant established good cause, resubmit the case for a summary of its merits.
The appeal tribunal decision should be affirmed. Regarding good cause, the claimant was not prevented from attending the hearing due to circumstances beyond her control. The claimant stated she forgot. Accordingly, the claimant did not have good cause for her non-appearance. As to the job separation, the claimant quit for personal reasons unrelated to her work. Therefore, the claimant quit without work-connected good cause, and we should affirm the AT decision. Claimant did not have good cause for her non-appearance, voluntary leaving, no chargeback.
Reverse the AT. Claimant established good cause for AT1. Resubmit. Memo to investigate possible unreported earnings.
We will resubmit the case and send the memo.
Case number 3149638, Commissioner Demerson.
The commission should remand this case to the appeal tribunal. The available record suggests that the hearing officer failed to properly develop the record about the final incident which led to the claimant's separation. Since the parties were not adequately questioned, and because testimony about the final incident is vital to the proper resolution of this case, we should remand this case to the appeal tribunal to develop the record about the circumstances which led to the claimant's separation.
The decision is not correct. The employer has alleged that the claimant was discharged due to poor attendance and damage to company property. The last alleged incident of tardiness was almost 2 months prior to the claimant's discharge, and no firsthand testimony has been provided to establish that the claimant was responsible for property damage. The claimant is the only party to provide firsthand testimony, and the claimant has denied the employer's allegations. The employer has failed to establish misconduct. Reverse the AT, no misconduct, chargeback.
I concur with Commissioner Demerson.
We will remand the case to the appeal tribunal. And this one, you can dissent to this if you disagree.
Yes, I want a short form dissent.
Thank you.
Case number 3155-103, Commissioner Trevino.
The decision is correct. The claimant is the only party to provide firsthand testimony. He was discharged for failing to work on November 14th, 2021. The claimant has consistently provided that he was not scheduled to work that day and never scheduled to work on the day of the week, on that day of the week. The employer witness admitted that they were not aware if the claimant was scheduled to work that day. The documentation provided does not establish the claimant was informed he was scheduled to work on November 14th, 2021. The employer has not provided evidence of misconduct. Affirm the AT, no misconduct, chargeback.
The appeal tribunal decision should be reversed. The claimant accumulated more absences than what was allowed for under the employer's policy. The claimant's final absence was a no call, no show. While the claimant disputes he was scheduled to work on the day of his final absence, the employer submitted its work schedule, which shows that the claimant was scheduled to work. As such, the claimant's final absence, in light of prior warnings, constituted work-connected misconduct. We should therefore reverse the AT decision, misconduct, no chargeback, adequate employer response.
Reverse the AT, misconduct, no chargeback, adequate employer response.
Short form dissent.
Yes, sir.
Case number 3214070, Commissioner Trevino.
The AT decision should be reversed. The claimant notified the employer 3 hours before the start of his scheduled shift that he could not complete the 80-mile commute to work due to icy road conditions. The employer told the claimant that he would be fired if he did not report to work. The claimant quit due to the employer's hostility and threatened discharge. Because the claimant was unable to report to work due to the severe weather conditions, the employer's threat of discharge was unreasonable and provided the claimant with a good cause connected with work to quit. Reverse the AT, no voluntary leaving.
The appeal tribunal decision should be affirmed. The claimant's description of the job separation tended to vary as his case worked its way through the appeal process. In fact finding, the claimant first stated he was fired, but then gave a later fact-finding statement that he resigned, only to then testify at the hearing that he was told he would be fired if he did not come into work. The employer, on the other hand, was consistent in his description of the job separation. The employer's fact-finding statement and claim response both state that the claimant resigned. Given the aforementioned, the appeal tribunal, who was in the best position to gauge the credibility of the claimant, should not have had its decision disturbed. We should therefore affirm the AT decision, voluntary leaving.
Affirm the AT, voluntary leave.
Short form dissent.
Yes, sir.
Case number 3235197, Commissioner Trevino.
The AT decision is not supportable. The employer claimed that the claimant was discharged for attendance, and they alleged that the final incident occurred when the claimant supposedly refused to respond to an emergency call. However, the evidence did not support the conclusion that the call for assistance made to the claimant was an emergency, or that the claimant was made aware that it was an emergency. There also is no evidence that the claimant was scheduled to be on call at the time or otherwise required to be available to answer calls while he was not at work. The employer has not provided any on-call policy or even alleged the existence of such a policy. The only credible evidence established that the claimant received a text message asking if he could help out a coworker. The claimant could not assist with the request for assistance because he was not in town at that time. Absent some evidence of a policy that the claimant violated, the employer has not met the burden to establish misconduct connected with the work on the final incident. Reverse AT, no misconduct, void adequate response ruling.
We should modify the appeal tribunal decision. The claimant had excessive incidents of tardiness and absences, including several no-call, no-shows during his first 30 days of employment. The claimant admitted to several of the attendance infractions and acknowledged that he had been counseled about this issue. Ultimately, the claimant failed to respond to a text from his supervisor and did not carry out his assigned duties. Because the claimant mismanaged his position of employment, we should modify the AT decision, misconduct, void the adequate response issue.
Reverse the AT, no misconduct, void adequate response.
The majority vote is no misconduct.
Short form dissent.
Thank you.
Thank you.
Case number 3230048, Commissioner Demerson.
Commission should conduct a rehearing in this case. The employer in their appeal to the commission stated that they had additional documentation and a firsthand witness who could provide testimony about the final incident which led to the claimant's separation. Since the additional evidence and testimony from the employer's witness is critical to ascertain the nature of the claimant's separation, we should conduct a rehearing to obtain testimony and to admit the employer's additional evidence.
The AT decision should be affirmed. The claimant received a promotion and corresponding salary increases effective March 1st, 2022. The claimant testified that she was provided a spreadsheet of salary changes for the claimant and other employees by her direct supervisor and told that the changes were approved, so the claimant implemented the changes. The employer's witness have no firsthand knowledge of the events in question, but alleged that the claimant implemented the changes prior to approval. Pursuant to commission precedents, since the claimant denied allegations of misconduct under oath and the employer presented only secondhand testimony, the employer did not carry its burden of proving that the claimant committed misconduct. Affirm the AT, no misconduct, chargeback.
Rehear.
We will rehear the case.
Case number 3315943, Commissioner Demerson.
We should reverse the appeal tribunal decision. The claimant was aware of the employer's policy. The claimant was discharged when she made a racially insensitive statement towards a coworker. The coworker complained to management, which ultimately led to the claimant's discharge. Since the record shows that the claimant was aware of the employer's policy, but thereafter violated the policy through her insensitive behavior towards a coworker, the claimant's inactions amounted to misconduct. Hence, we should reverse the appeal tribunal decision, misconduct, no chargeback, adequate employer response.
The AT decision should be affirmed. While training a new employee, the claimant used a phrase that offended the new employee. The claimant had no intent to harass or discriminate against the new employee. Additionally, the claimant was unaware the phrase could be interpreted such as a violation of the employer's policy, as the same phrase had been used by other employees that trained the claimant and had been used 10 to 20 times while training other employees. As the employer had condoned the use of the phrase in its workplace, the claimant discharged without warning for simply repeating the phrase did not constitute misconduct. Affirm the AT decision, no misconduct, chargeback.
Affirm the AT, no misconduct, chargeback.
Short form dissent.
Yes, sir. Commissioner Demerson.
Case number 3326843, Commissioner Demerson.
The commission should grant a rehearing in this case. The claimant quit her job due to a dispute about her commission pay. We should therefore conduct a rehearing to further develop the record on the following points. First, the claimant stated that one of the employer's explanations for lower commission pay had to deal with a particular enrollment component referred to as OPR. The record should be developed to directly ask the parties if this parameter was discussed with the claimant as part of her commission agreement. Second, the record should be developed as to who the claimant spoke to at the employer's business regarding her concerns. The claimant specifically identifies one individual she spoke to, the HR manager, and the HR manager provided a firsthand denial that the claimant ever mentioned the issue of commission. Developing the record with regard to whom the claimant spoke to would provide the commission with the best evidence as to whether the claimant properly escalated her concerns before quitting. Third, the record should be developed as to whether the claimant's reduction in commission rate constituted a 20% or more reduction in her earnings. Fourth and lastly, the employer states in its appeal to the commission that it had accurate information that was not available during the hearing, and accordingly, the employer should be allowed to present its evidence. As such, the commission should conduct a rehearing for these reasons listed, stated.
The AT decision should be affirmed. Per the claimant's contract, she was to be paid base salary plus 5% commission. In January 2022, the claimant began to notice that she was not being compensated correctly. Each time the claimant attempted to resolve the issue with the employer responded with a different reasoning and continued not paying the claimant for her full commission. After 6 months of trying unsuccessfully to resolve the issue with the employer, the claimant resigned. Pursuant to TWC precedents, the claimant had good cause connected with the work to quit after making a reasonable effort to resolve legitimate complaints with management. Affirm the AT, no voluntary leaving chargeback.
Rehear.
We will rehear the case.
Case number 3384017, Commissioner Trevino.
The AT decision is not supportable. The claimant's testimony under oath that the employer initiated the separation should be given greater weight than the employer's exclusively secondhand or hearsay statements. First, the employer initiated a discussion with the complainant in hopes that the complainant would resign. However, she did not resign. Then the employer posted the claimant's position in an online job posting. When she questioned the employer about the posting, he admitted that he had hoped she had resigned, and they agreed that she could continue to work for 2 weeks or until things were ready for her replacement. When the claimant texted the employer that the work was complete, he texted back, "God bless, take care." No further work was offered to the complainant, and she was separated for reasons other than misconduct connected with work. Reverse the AT decision, no misconduct, correct employer's account number, and memo to the tax department to investigate whether the claimant was an employee.
The appeal tribunal decision should be affirmed. The claimant stated that she was never told she was discharged. The preponderance of the credible evidence establishes the following. The claimant was only able to work part-time in the office, as she expressed concern about commute time. To accommodate the claimant, the employer allowed her to come into the office on a part-time schedule, but also put in a job posting to have someone else to be at the office full-time. The claimant mistook the employer's job posting as a notice of termination, and per the employer's fact-finding statement, notified the employer that she was overwhelmed and that she gave up. In addition, the claimant testified that the employer provided her with assurances that she would have further work. As such, the claimant quit while work was still available and without work-connected good cause. We should therefore affirm the AT decision, voluntary leaving. In addition, we should correct the employer account number.
Voluntary leaving, correct employer account number, memo to investigate employment versus independent contractor status.
Short form dissent.
Yes, sir. And your memo will go through.
Thank you.
Case number 3384600, Commissioner Demerson.
We should affirm the appeal tribunal decision. The employer implemented a zero tolerance policy on harassment at the workplace. Claimant was terminated when the employer's investigation revealed that the claimant had behaved in an inappropriate fashion towards a coworker. The employer in his documents submitted to the commission provided statements from multiple firsthand witnesses which evidenced the claimant's wrongdoing. Since the preponderance of the evidence suggests that the claimant violated the employer's zero tolerance policy on harassment by engaging in inappropriate conduct at the workplace, the claimant's actions arose to misconduct. Hence, we should affirm the AT decision, misconduct, no chargeback.
The decision is not correct. The claimant is the only party to provide firsthand testimony, and the claimant has denied the allegations. The employer has not provided sufficient evidence to establish misconduct. Reverse AT, no misconduct, chargeback.
Reverse the AT, no misconduct, chargeback, memo to investigate possible unreported earnings.
Short form dissent.
Yes, sir.
Thank you.
And we will send that memo. That was the last case pulled for additional discussion on docket 1. You should have received the UI short form dissent list for docket 1.
I move we accept staff recommendations on the remaining UI cases on docket one, except for the case on which I am dissenting as reflected on the UI short form dissent list for docket one.
Second, the chairman's motion, except for the cases on which I'm dissenting, is reflected in the UI short form dissent list for docket one.
I concur with Chairman's motion, except for those cases in which I am dissenting, as reflected on UI short form dissent list for docket one.
Motion passes with the exceptions noted.
Thank you very much.
Thank you. That's the end for agenda items 3 through 7. We'll take a short recess.
Yeah.
Yes, thank you.
This is agenda item A, AEL Advisory Committee Annual Report.
Good morning, Chair Daniel, Commissioner Dimerson, Commissioner Trevino, and Mr. Cerna. For the record, Mahalia Baldini with the Workforce Development Division. Texas Labor Code, Chapter 315.005 requires the Texas Workforce Commission to establish an Adult Education and Literacy Advisory Committee, which is charged with reporting to the commission annually and advising the commission on various aspects related to the enhancement of adult education and literacy in Texas. I want to thank the advisory committee members for their contributions over the last year that led to today's recommendations. I have with me today the AEL Advisory Committee Presiding Officer, Steve Banta, who is also the Executive Director of Literacy Texas. He will be addressing the commission today to present the 2022 annual report and recommendations. However, I wanted to take just a moment to address the recommendations from the last year. And with regards to the committee's 2021 recommendations of working with employers on projects and partnerships that provide vocational and employability skills, specifically digital literacy skills. TWC contracted with the Texas Center for Advancement of Literacy and Learning to advise the adult education and literacy content standards and to include specific standards for digital literacy. The development is underway and the statewide rollout and implementation of the standards is set to occur in fall of 2023. Also, through our statewide professional development center, we partnered with Tyson Foods to roll out digital access and resiliency at Tyson, also known as DART. This was a collaborative project focused on the use of AEL providers to work on site at Tyson facilities across the state to instruct incumbent workers with key digital skill building curriculum that allows them to be more marketable within the vast career opportunities at Tyson Foods. We were able to revise that curriculum and to work on a broader range of employers and replicate the project to expand digital literacy curriculum to support employers across the state that partner with adult education and literacy providers. The 2021 report also focused on services for justice-involved individuals and recommended that TWC take a collaborative approach that enables incarcerated individuals participating in pre-release education and training programs to complete certificates and certifications, and creating post-release opportunities for those individuals to connect with second chance employers. In response to that recommendation, TWC went into an interagency contract with Windham School District to develop integrated education training programs for individuals within 2 years of release to be enrolled in training, obtaining credentials and certifications in high demand occupations, and then upon release will be connected to employers. This project brings the Texas Department of Criminal Justice, Windham School District, Texas Workforce Commission, and our AEL statewide local providers into a collaborative partnership. This project is currently underway at 2 women's facilities with the potential to expand in the future. At this time, I would like to turn it over to Steve Banta to present this year's report and recommendations. Mr. Banta.
Thank you, Mahalia. Good morning, Chairman Daniel, Commissioners Demerson and Trevino, and Mr. Cerna. For the record, my name is Steve Banta, presiding officer of the AEL Advisory Committee and Executive Director of Literacy Texas. The committee met 4 times in 2022 and focused on 3 main areas that were of concern to the committee members: the digital divide, both urban and rural, collaboration among agencies and community-based organizations to provide adult literacy services, and 3, how innovation can expand capacity and services to help ensure best use of limited resources. The committee referenced the AEL strategic plan goals and objectives to arrive at our recommendations. It is important to point out that the TWC AEL program has made considerable progress in the 3 areas outlined above. The committee focused on areas where we thought our expertise would be helpful. First recommendation: Mr. John Trischetti, Executive Director of the Literacy Coalition of the Permian Basin, presented to the committee about a comprehensive needs assessment they conducted that involved all organizations working to address adult literacy in the Permian Basin. They engaged Dr. Ray Perryman, a nationally recognized economist based in Texas, to evaluate the economic impact of low literacy rates in the region. The study made clear to businesses and elected officials the urgent need to address the issue and created the platform and recommendations to move the Permian Basin forward. This committee believes that a similar study done on a statewide basis would clarify the magnitude of the challenge for businesses, communities, and perhaps most importantly, public policy makers who are in a position to address the issue. Second recommendation: Mr. Christopher Mammon, Director of Workforce Development, Greater San Antonio, presented on the Talent Pipeline Model, or TPM, industry collaboratives initiated by the U.S. Chamber of Commerce Foundation. TPM has 6 strategies to identify, develop, and source talent for in-demand and high-growth occupations. The committee recommends that TWC evaluate the TPM model for use by AEL programs. This could provide a highly effective way to match AEL programs with local employer needs. Where employers use the TPM model, TWC can develop a toolkit with a curriculum for key industry sectors that not only addresses literacy, numeracy, and language skills, but also digital literacy and soft skills. Third recommendation: the digital divide is one of the most complex issues for the TWC to address. There are a myriad of federal, state, and local initiatives to address the issue. To keep it manageable, the committee recommends that TWC focus on barriers to access their programs. The first step would be to conduct a digital literacy and equity assessment to better understand the barriers AEL students encounter while trying to access online services. The assessment could be used to eliminate the barriers through strategic partnerships with libraries, workforce solutions offices, CBOs, and other adult literacy organizations. Fourth recommendation: Mr. Adrian Lopez, CEO of Workforce Solutions Alamo, or WSA, presented on the Ready to Work program funded by a 1/8 cent sales tax in San Antonio. It is characterized by a no wrong door initiative. WSA created a consortium with major nonprofits such as United Way, San Antonio Food Bank, YWCA, Opportunity Home Family Security, and Texas A&M. The committee recommends that the TWC examine this model for ways to promote collaboration between agencies, CBOs, and workforce solutions to create the no wrong door process to better serve participants. This means that no matter where an individual enters the system for social services, an intake record is created and they are directed to the services they need. No more telling them that they are at the wrong place and sending them on their way. Intake personnel attend an academy to ensure they are knowledgeable of all services available. This would be a significant undertaking for the TWC to implement the no wrong door model statewide, but the program in San Antonio appears to be generating significant benefits that would be enjoyed on a much larger scale. Fifth recommendation: The committee advises building on the 2021 recommendation to collaborate with Texas employers on projects and partnerships that provide workforce preparation and vocational skills for AEL customers. Also, the committee recommends providing robust support for engaging special populations to meet employer needs. Additionally, create a toolkit to provide a standardized curriculum for workplace literacy classes in key industry sectors, including employability and digital literacy skills. I want to thank my fellow committee members, Diana Contreras, Leslie Cantu, Rita Hernandez, Johnine Maldonado, and Brenda Schofield for their contributions to the development of these recommendations. Thank you also to Mahalia Baldini and her team for their support and guidance over the past year. This concludes my report.
All right, thank you very much, Mr. Banta. Any comments or questions?
Chairman, I'd like to, first of all, thank you guys for the recommendations that have been stated here. Mr. Banda, thank you for your work on our AEL advisory board as well. In particular, recommendation 1, let me know how I can help as a commissioner representing employers, getting the word out to those employers about these opportunities that are out there. And if you have Dr. Perryman engaged, you have the best of the best in that regard. And so look forward to working with you there. And all of the recommendations, anywhere that I can play a role, I want to do that. And then looking at recommendation number 5 as well, where you want to collaborate with Texas employers on projects. Again, my office stands ready to work with you in that regard to do what we can to make a difference in that space. I believe the programs and what you're doing benefits our Texas employers in a big, big way. And so we look forward to working with you and appreciate the recommendation and the work of the advisory board to push these forward.
Thank you.
Thank you, Molly and Mr. Banta. I too appreciate your comments and I do look forward to working with both of you. Thank you.
Thank you.
Again, thank you very much. We work with Mahalia very closely, and certainly the advisory committee has been very important to us. I tell every advisory committee member for every advisory committee the same thing. We really appreciate your volunteer service. It is, we know the hours are great and the pay is even better. I mean, that's about all we can offer. But without your input, we really can't do all the things that we do. So thank you for everything that you're doing. Thank you for this report. And moving forward, we'll certainly work on these things, but there'll be many other things to work on. We look forward to working with you on this.
Thank you very much.
Thank you.
Thank you.
All right. Let's move to agenda item 9. This is child care match.
Good morning, Chair Daniel, Commissioners, Mr. Cerna. For the record, Sandra Williams, Workforce Development Division. This morning, the Workforce Development Division and Child Care and Early Learning brings forward child care match agreements received through December 31st of last year. Supporting documentation includes 38 board contract year 2023 match agreements from 13 boards. Those boards are Alamo, Concho Valley, Greater Dallas, East Texas, Gulf Coast, Lower Rio Grande, North Central Texas, Northeast Texas, Panhandle, Rural Capital Area, South Texas, and Tarrant County. These boards have currently secured 80.57% of their required match for BCY 23, with 8 boards securing at least 50% of their match and 10 boards securing 100% of their match. Staff recommends acceptance of child care pledges, donations, transfers, and certifications of expenses for BCY 23 in the amount of $15,817,669.
Any comments or questions?
None here.
None here.
Is there a motion?
Chairman, I move that we approve the acceptance of child care pledges for donation, transfers, and certifications of expense for board contract year 2023 as recommended today by staff.
I second the motion.
It's been moved and seconded and we're unanimous. Thank you.
Thank you.
So agenda item 11, board nomination.
Hello there. Good morning, Chairman, Commissioners, and Mr. Cerna. For the record, Shanta Williams with the Workforce Development Division. And today before you for consideration, we have workforce board nominations for Workforce Solutions Deep East Texas, Greater Dallas, and North Texas. Staff recommends approval on the presented nominees, and I'm here to answer any questions you may have.
Comments or questions?
None here.
And none here.
Is there a motion?
Chairman, I move that we approve the local workforce development board member nominees presented today for the following workforce solution areas: Deep East Texas, East Texas, Greater Dallas, and North Texas.
I second the motion.
It's been moved and seconded and we're unanimous.
Thank you.
Thank you. Is there a legislative report today? There is? He's not trying to pull some sort of camouflage maneuver this week like he has in the past. I take it that must mean you gave him a stern talking to about his tie.
Since he has a tie.
We have to guess which tie he's wearing to determine. Let's just keep talking about him like he's not standing at that podium. This is an awful lot of fun.
Didn't want to waste a perfectly good tie this morning.
Thank you very much for that.
Good morning, Mr. Chairman, Commissioner Dimerson, Commissioner Trevino, Mr. Cerna. For the record, Michael Britt, Governmental Relations. This evening, President Biden will deliver his State of the Union address to a joint session of Congress at 8:00 p.m. On the federal side of things, GR is monitoring 2 federal hearings this week. Today at 1:00, the U.S. House Energy and Commerce Subcommittee on Innovation, Data, and Commerce is holding a hearing to mark up HR 752, the Securing Semiconductor Supply Chains Act of 2023. On Wednesday at 9 a.m., the U.S. House Ways and Means Committee will be holding a hearing on unemployment insurance fraud. Regarding the state legislature, the Senate Committee on Finance will hold its hearing on TWC's budget and legislative appropriations requests next Tuesday, February 14th at 9 a.m. And that concludes my remarks. I'm happy to answer any questions.
Any comments or questions?
What time did you say? What time for the February 14th hearing?
For the Senate Finance hearing,
Yes.
9 a.m.
9 a.m. Okay. Thought I heard 8. Okay, thank you.
Thank you.
That's Valentine's Day.
Yes, sir, it is.
Go while you can, Michael.
Michael dutifully was waiting for the next comment. Is there an executive director's report today?
No, sir, I have nothing to report today.
I have one request for you.
Yes, sir.
I would request that staff bring forward a discussion paper on a middle skills rapid training initiative for employers to access.
Okay.
Thank
Yes, sir.
you. Is there any other order of business coming before the commission?
Mr. Chairman. I'd like to thank and congratulate Julia Mercado. I asked her to be my chief of staff for the Office of Labor, and she has accepted. So I'd like to thank Julia for that and welcome her to the team.
Chairman, I do, it's just jogged my mind. I wanted to thank those members of the Texas Industry Association session. We had Gardner Tate, the governor's office, come over, the governor's chief of staff to come address that that group, and just continue to appreciate the collaborative efforts that are taking place, especially with that industry association and during this legislative session. So for the record, I wanted to just say our appreciation to the Gardner and the team for coming over to do that.
Absolutely. Thank you. Well, congratulations to Julia. She does have one unfinished piece of business. We're supposed to have a pyrotechnics show after one of the commissions. So I still am expecting that.
Okay.
You've definitely selected someone who I think will do a great job for you. Any other business? I do have one last thing. So Super Bowl is Sunday. The Kansas City Chiefs are playing, I think, a team from Philadelphia. I'm not sure. Mr. Trobman has like an unhealthy level of excitement about this football game. He's mentioned it a couple of times. I mean, I don't really have a dog in the fight, except Dallas can't seem to put something together for the last 27 years. And so I have followed Patrick Mahomes' career while he was at Texas Tech. He's done a phenomenal job at Kansas City. I think Philadelphia has a quarterback. I don't know who it is, but Mahomes has done a great job. There is another Red Raider on the Philadelphia team. It's a linebacker, Zach, but you know, he was at Tech briefly. He was a transfer student. Mahomes put in his whole deal. So I've adopted Kansas City as my team. And so here's what I'm saying. Just a friendly gentleman's agreement, but this is what I would propose. If for some reason I can't fathom Philadelphia wins this game, I would provide Mr. Trobman, if he accepts, the closest thing I can come to Kansas City barbecue here in Texas, which of course is all better than Kansas City barbecue. If, as I expect, Kansas City does in fact win the football game, I would ask Mr. Trobman to provide me or to join me, and he would treat me and him to a cheesesteak, an appropriate cheesesteak. Pat's or Geno's would be great, but the closest thing we can get to in Austin, Texas. And since I'm pretty confident in what I'm saying, just so you know, I like Cheese Whiz on mine with ribeye for the steak. So if Mr. Trobman accepts the challenge, it'd be, should Philadelphia win, be some Kansas City style barbecue from me to Mr. Trobman, and if Kansas City wins, which I would anticipate, Mr. Trobman would provide cheesesteaks for me, and we would enjoy that meal together. It would be something we could do together. So, oh, he's on.
He's on.
There we go. It is done. Anything else before the commission?
I think next Tuesday we'll know the results.
Yeah,
So-
that's right. Hopefully I'll have, cheesesteak on my shirt, not barbecue sauce on his tie. So is there a motion to adjourn?
So moved.
I second the motion to adjourn.
Been moved and seconded to adjourn, and we're adjourned. Thank you.